Testing 1 2. Testing 1 2. That actually looks pretty good. Let's see what we got going on. Testing 1 2. Testing 1 2. All right, what's up, everybody? Supreme Decisions here, and I'm actually doing something a little different today, and that's I'm working with the microphone that literally I bought like 2 years ago and just stopped using for whatever reason. But those of you that had an opportunity to check in to the members only masterclass for challenging subject matter jurisdiction, is going to be up for those that are in the masterclass. You got two levels. You have the entry level and those that are really studying to be, well, hell, make this a living for them. But today I wanted to bring to you Crawford v. Washington. And the reason why I'm doing that is because this case is a fundamental case that really broke down the fashions of getting rid of hearsay and giving you the ability and power to actually make sure it is not part of your case if it's executed correctly. And this is a great part for a zealous criminal defense. Now we have Crawford v. Washington, 541 U.S. 36, and it's a 2004 case. Now, the case held, Michael Crawford was charged with assault and attempted murder. His wife gave a recorded statement to police that incriminated him. She didn't testify at trial because of marital privilege, but the prosecution still introduced her recorded statement. Now, the Supreme Court ruled that admitting the wife out of testimony statements or testimonial statement violated the Sixth Amendment Confrontation Clause because Crawford had no opportunity to cross-examine her. Now, here are the key rules and why I'm bringing this up and why this case is so important. Testimonial statements given to police during questioning, affidavits, prior testimony cannot be admitted against a criminal defendant unless the witness is unavailable. Now, unavailable has a lot of caveats behind it. So they must be in line with what is going on and how it falls under the reason they're unavailable. A defendant had a prior opportunity to cross-examine them. Now, this is more useful in civil litigation, not criminal. Now, here's the flip side of that. Marital privilege extends both ways. The admission automatically sets up an overturning because, one, his wife cannot testify against him. That's one. Two, when it's admitted, there must be confrontation. This is an adversarial system. Why is this important in a criminal case? Statements given during police questioning. That also includes police reports, police affidavit, police scene reports. Why? Because these are testimonial assets that should be made known to the defense, but the defense must request them. Two, this is another caveat. I don't recommend, and I very seldom use affidavits. Why? Because they cannot be admitted because they are testimony, and they have to be brought in as such, but it can't be heard until trial. So whenever you're filing an affidavit, you're just giving them your playbook. This is why these are things that are set and left for trial. There is a time and there's a place for affidavits. It's not when you're filing a criminal complaint. You have every right to do that. Not very wise to do if you plan on winning. Now, these are the things that you also have against police officers, because they will not make themselves available for questioning. So the prior opportunity to cross-examine them is automatically out. So anytime they write a report, you must have the opportunity to cross-examine them. If not, you have an out in your case, because you must be able to cross-examine all witnesses against you. Okay, there we go. I don't know why that looked like that. Anyway, now these are things that I want. Again, this is about winning for me. This is why I give this to you. Why this matters for criminal defense. Before Crawford, courts used a looser test, which is Ohio v. Robertson, a 1980 case, where hearsay could come in if it was deemed reliable. Again, there's a process for reliability. Crawford shut that door. Reliability isn't enough. Confrontation through cross-examination is the constitutional requirement. Say that one more time. Confrontation through cross-examination is constitutional requirement. That is the Sixth Amendment. If an officer writes a statement, you must have the opportunity to speak to them through cross. And if that's not made available, that case is over, because the prosecution is using that police officer's testimony as it is written. And you have the right to not only challenge the statements, you have the right to challenge the officer. You also have the right to the officer's character. So this is why you do this in a certain procedure. And you follow just basically dropping the breadcrumbs for you. Line by line, precept upon precept. These are the things that you need. So as a defendant, Crawford is a constitutional shield to keep damaging out-of-court statements away from the jury. So this is why you're forceful and you're putting these things into practice as they are necessary. Now, how does it apply in actual practice? You can use Crawford for challenging police reports and statements. If officers try to introduce a witness statement taken during the investigation, make sure you have the 911 calls, all police interviews, all affidavits taken by police and also written by police. You can use this testimony and make it inadmissible. The witness has to be available for confrontation. That's why it's called an adversarial system. Now, and this one is going to be kind of touchy, because it's talking about the idea of blocking DV statements. In DV cases, prosecutors often rely on victim statements made to police when victims don't testify. Crawford is the main defense to exclude those. This is the biggest reason why you need to make sure any witness against you is there, and if not, it cannot be used. This is your shield. Crawford v. Washington. No, it's not a boxing match. However, that is also what this is. See the play on words? Anyway. Now, suppressing lab reports and forensic evidence. Later cases, Melendez-Diaz v. Massachusetts in 2009, Bullcoming v. New Mexico in 2011, extended Crawford to lab reports. A forensic report is testimonial unless the analyst testifies in court. They can't just use the report and not have the person who took the report testify. If that happens, you have been wronged. And then you must be able to either get that case reheard, or you can now sue because it also had to have been requested by your defense attorney if that's what you got. Always understand this. The record starts and stops with you. And if you don't do what you're supposed to do, they lose the obligation to have to. So remember, make sure you understand anytime there's a lab report, if there's a forensic report, you have the opportunity or you have the right, the desire, the need, the anything that you want to use in that loose frame to challenge the testimony of the analyst in court through cross-examination, because that is your right. Because this is an adversarial system, you have the right to confrontation. Always remember that. Now, here's the next part. This is the greatest opportunity for you to use Crawford v. Washington, because it prevents backdoor witness testimonies. Sometimes prosecutors try to bring in statements under hearsay exception, like excited utterance or a medical diagnosis. The defense can argue if the primary purpose was for prosecution, its testimonial is barred under Crawford. So if it's about prosecuting, hearsay cannot be brought in whatsoever. Now, here are limits and exceptions. Non-testimonial statements are not covered by Crawford. This is what we got here. 911 calls during an ongoing emergency, which is Davis v. Washington. It's 2006. Remember, I always say, if they say they were called out, it was a call to service, get that call. Use their words against them. Because if they lied, guess what they have to now admit in front of the jury? That they lied to you. And even someone constantly saying, oh, I must have misspoke, or I don't know. All those are things that go in your favor. This is how you weaponize your defense. I give you this so you can now go into battle not only with a shield, but you can also go out there with a sword. Now, casual remarks to friends and family. This is the other case that I spoke about. Stop talking to everyone about your cases. Once you have it, you keep it close to the vest. You make sure everybody doesn't know your business, because like I told you, the biggest thing against you is your trust of others. You cannot trust it because they will weaponize it against your friend. And if your friend isn't built tough, you'll find out and it'll be in detriment to you. Now, business records cannot be created for prosecution. Business is a civil thing, which is why everybody does business and they separate it from their personal, which is why a lot of times when you see these federal cases that are going after these persons, they're separating the personal acts away from their business acts, because they are, whether we like it or not, are two separate things. Now, you may be on a business trip and commit a personal act, but while you're on that trip, you're not conducting actual business. That's the way it's worded and set up for cases against you in your personal. Now, here's the great part. This is where the fun comes in at. Defensive strategy summary. Now, identify every piece of hearsay that the prosecution wants to introduce. Ask what this statement made to law enforcement or for trial purposes, and ask how it's going to be used. If it's testimonial, file a motion or make a trial objection under the Sixth Amendment Confrontation Clause. argue strict Crawford standards without cross-examination, the statement must be excluded regardless of its reliability. Now, when you're putting in a plan for your defense, is file a Crawford motion to suppress any testimonial statements from unavailable witnesses. At trial, object immediately when the state tries to introduce testimonial hearsay. Force the prosecution to put an actual witness on the stand. I'm going to read that one more time because this is where it gets fun. Object immediately when the state tries to introduce testimonial hearsay. Force the prosecution to put an actual witness on the stand. Don't allow them to just run over and say anything and do anything and then not be responsible for what they've done. Always remember that. Now, if they get in and you're on appeal, if such a statement was admitted, raise a Crawford violation as reversible constitutional error. Because the bottom line, Crawford v. Washington is one of the strongest confrontation tools for the defense. It forces the state to bring live witnesses for cross-examination instead of hiding behind hearsay. This is your greatest tool when you're trying to make them convict you of an actual crime. Again, this is also why they don't like trials, because when you're on your P's and Q's, or as a lot of people like to say, if you're actually standing on your square, that's what Crawford comes in for. Understanding how to have these cases and how to weaponize them and use them is the separation. Because you have a lot of people that come on here and talk, and that's all they're doing. They're doing this, but they have no idea how any of these cases apply, nor how to use them effectively. Because even when you're doing this, there has to be a direction that you're going in. Always understand that the application is more important than just having the tools, because just like I told you about a chessboard, everybody has the same ability. Everybody's locked into certain moves, but not everybody understands how to use every piece. And the more you become familiar with the movement of each piece, and you create a bona fide strategy, and you're able to adapt to what's coming to you, you are then able to be effective and win. That's why you come to me. That's why you're watching. And Supreme, right now I'm out. And I have another show that'll be coming up shortly. So stay tuned. Don't forget, got my email contact in the description, as well as you can set up a consultation. Just click the link in the description, hit the time, and let's go. Let's go and let's grow. Supreme, I'm out.